Hi friends, this is immigration attorney Christian Alvarez, and today we're going to be discussing President Biden's executive order for parole in place issued on June 18th, 2024. So stay tuned, we have a lot to cover. Okay, so let's talk about this executive order issued by President Biden. What is it? It is a measure that provides individuals who are married to U.S. citizens who have also been living here in the United States for at least 10 years and have otherwise good character or good moral character for them to apply for a benefit called parole in place. Now, why would someone need this benefit of parole in place? Well, there are individuals who, as I mentioned before, have been married to a U.S. citizen, have been living here 10 years, but they don't qualify to obtain a green card or permanent resident status within the United States because of the way they entered the country when they did so. The current immigration law states that for an individual to adjust status, meaning obtain permanent residency, that person, through a family petition, that person must be inspected by an immigration officer, admitted, or paroled into the country. So if an individual entered with a tourist visa or an H-1B visa or an H-4 visa and they marry a U.S. citizen, they already qualify to be petitioned and obtain their permanent residence through the adjustment of status process within the United States. But individuals that perhaps swam across a river or walked through the desert or hid in a car or came in some irregular fashion, because they were not admitted nor paroled, they are currently required to leave the country to obtain an immigrant visa abroad after an interview at the U.S. consulate, and then they can return to the U.S. Now, that process is currently taking around 5 years because it requires a waiver that takes about 3.5 years right now to get approved. During this 5-year process, individuals are not allowed to have a work permit, and they still have to leave the country and risk another possible inadmissibility being found in their case, and ultimately that can lead to them being outside of the country, not a matter of days, but maybe even a matter of years if they have any other inadmissibility that requires a waiver. So because immigration law states that individuals who are seeking adjustment of status by virtue of an immediate relative petition, meaning a U.S. citizen spouse petition, need to be either admitted or paroled, President Biden's executive order is covering the parole part, the parole requirement, by providing a method for individuals to apply for this process called parole in place. This process already exists at the moment, but it is limited to only family members of military members. So it is being expanded through this executive order to family members, to spouses of U.S. citizens who have been in the country at least 10 years, and to certain stepchildren of U.S. citizens if their parent is going to be obtaining parole in place as well. So let's take a look at this slide that I prepared here. Like I said, this executive order aims to assist individuals married to U.S. citizens who, due to their unlawful entry, they don't currently qualify for adjustment of status. It allows them to obtain the parole in place, which is one of the requirements. The parole in place, once it's granted by immigration, it will allow them to do two things. One, it's going to allow them to have a work permit. The work permit, USCIS has already said it's going to be valid for 3 years. And while the parole in place is active or issued, or after the parole in place is issued, now the individual can go ahead and file for adjustment of status or the green card application within the U.S. There's no longer going to be a need for a waiver or to leave the country and be further exposed to other inadmissibilities abroad. So this is a very amazing, order that's going to be helping approximately 500,000 individuals who are currently either stuck waiting for a waiver or too afraid to even apply because they don't want to leave the U.S. and face possibly being stuck abroad for some other inadmissibility. Okay, so we already spoke about that. Let's go on to our next slide. Who qualifies for this benefit? So as I said before, this is for individuals who enter the United States without being either admitted or paroled. This is for individuals who were married to a U.S. citizen on or before June 17, 2024. So as of the day of the proclamation, if they were not married to a U.S. citizen, they will not qualify. Now, one thing I do want to clarify is that Texas, among a couple of other states, which I will be listing up there, do recognize common law marriage. If the person is already cohabitating with their spouse and declaring them to be their spouse, they may be able to make an argument that they are already in a common law marriage. Now, if the state of Texas or other states, they recognize these common law marriages, then USCIS will also recognize that being a marriage. So if you are in a situation where you aren't yet married to a U.S. citizen, but you do happen to live in a state that recognizes common law marriages, definitely speak to an attorney so that they can help you with that requirement. The next requirement is for individuals who have been physically present in the United States for at least 10 years. For at least the last 10 years, you will need to prove physical presence in the United States from June 17, 2014 to June 17, 2024. And finally, individuals that warrant a positive finding of discretion, meaning they don't have any sort of disqualifying criminal history. There hasn't been sufficient clarification on what is exactly a disqualifying criminal history. Of course, immigration will be running background checks on every applicant, but the regulations to obtain, let's say, or the requirements to obtain DACA or deferred action are much stricter than the regulations to obtain a green card through adjustment of status. So I'm not too sure exactly where this sort of parole is it going to land. Or for DACA, if somebody has a DUI, they can't renew DACA anymore, but they wouldn't be disqualified for adjustment of status. So I'm not too sure exactly how they're going to be evaluating certain criminal incidents, like, for example, a DUI, but they will be issuing more guidance on that in the future. So let's talk about some preliminary questions and answers that USCIS has published. Basically, we already spoke about the first one, and what way does this help applicants? Basically, obtaining this parole will cure the unlawful entry and will allow them to remain in the United States with a work permit and apply for adjustment of status, meaning green card, and it'll save so much time from having to file a waiver and leaving the country. What about spouses of permanent residents? Well, actually, the USCIS website doesn't mention anything about spouses of permanent residents or any other family relationships like parents of U.S. citizens. So we will be waiting on perhaps more explanation to see if perhaps there will be an expansion. When the I-601A waiver first came out in 2013, they did not include spouses of permanent residents. It took about a few years for that to be expanded. So I'm assuming that the initial round is going to be limited to only spouses of U.S. citizens due to the large amount of applicants that do qualify. The third question is, can I request parole in place if I'm in removal proceedings? USCIS has already answered yes, you can. Even if you currently are in removal proceedings, meaning you are before an immigration judge and possibly facing deportation, you will be allowed to file this application for parole before USCIS. They will look at your specific requirements. It will be a case-by-case basis. But if you are granted parole, I do have to say it's very important. Individuals who are paroled in the United States, USCIS maintains jurisdiction over them, meaning that even if you are in court, if you are granted parole in place, you can obtain your green card before USCIS, and then that will give the judge an opportunity to dismiss your case. So That's a very, very good and different requirement, because currently for military members parole in place, if they are in removal proceedings, immigration was not allowing these applications to be submitted. So this is a very welcomed and nice change. Let's look at the last question. When can I submit my application for parole? Well, the application is not currently published at the USCIS website. USCIS first has to announce this proposed rule change, allow for a specific notice and comment period, and then proceed to publish the final rule. They are calculating that perhaps by the end of summer, we're not sure if that's going to be July or August, that the forms will be published and people will be given instructions as to how to send the application. Will it be available online only? Will it be available online and paper? Will it be paper only? And how much are the fees? As well as more explanation on the requirements. If you believe that you qualify and you want to know what documents you should start gathering, this is a preliminary checklist that they've mentioned, and it's also a preliminary checklist I've put together based on similar enactments. First of all, you need to obtain your passport. If your passport is expired or lost, head to your nearest consulate, make an appointment. There may be a little bit of an uptick on applications for passports, so go ahead and get started on that as soon as possible. Also, find your original birth certificate if it's very old or tattered, torn. If you can also get to your nearest consulate and get your birth certificate, a new original birth certificate, that would be great. Marriage certificate. Remember, you have to prove that you are married to a U.S. citizen, so have your marriage certificate handy. If you or your spouse were previously married, then you're also going to need evidence of how that marriage terminated. Was it divorce? Was it annulment? Or was it death? You'll need evidence of that. Next requirement is evidence of physical presence in the United States from June 17, 2014 to June 17, 2024. I recommend that you start a folder where you label every year: 2014, 15, 16, 17, 18, 19, 20, 21, 22, 23, and 24, and add a couple of pieces of evidence for every single year. If you don't do that, immigration will absolutely come back and request for more evidence. So it's important. That's probably going to be the biggest piece of homework that anyone interested in this case, it needs to get started on. Another requirement is, of course, evidence that your spouse is a U.S. citizen, so your spouse's naturalization certificate, their passport, or if they don't have either naturalization certificate or passport, their birth certificate. I recommend that it be a long form birth certificate, has mom and dad's name as well. There are some very tiny little certificates. USCIS does not accept those. And finally, any disposition records for any arrest or citation. If you have ever been arrested, even if that case was dismissed, it is important to obtain a certificate of disposition in the court where your case was handled. This is a very standard document to request, and there are records offices in all these courts. Just go into the records office, ask for the certified disposition, make sure that you get that disposition has a court seal on it, and get multiple copies. Get 2 or 3 copies just so that you can send one for the parole in place. And once your parole in place gets granted, you already have another copy for your green card application, adjustment of status, called adjustment of status. And that's everything I have for today. The only other thing I want to mention is be very wary of any professional or any individual wanting to take money from you at this point to perhaps put a down payment on this case. Historically, every time there is an executive order that brings some sort of immigration benefit, this order is almost always attacked through lawsuits, through litigation. As some of you may or may not be aware, when deferred action or DACA for childhood arrivals was enacted, it faced a lot of litigation. The second round, or the expansion of DACA, never came to fruition. There are many people who applied for the second round of DACA and it's still lingering. The application is just suspended, not being adjudicated because of a court order to stop the processing of these applications. So for now, my recommendation is inform yourself on the requirements, start to collect your documents. You can feel free to, have an appointment with an attorney to talk about maybe other options, or to ask any questions that may be very special to your situation. But I don't recommend right now you start to shell out stuff or even send anything to USCIS. If you do, they will reject it. So be very careful of that. Feel free to follow us. That's all we have for today, but feel free to follow us on any of our Instagram or Facebook or YouTube channel. That's all we have. Take care.